Hello, everyone. Good afternoon, and welcome to today's webinar hosted by the Federation of Credit and Financial Professionals and our technology partner, Credit2B. Today we have Michael Zweiback and Paul Regali, who are partners at Aaron Fox LLC, and they will be presenting on electronic signatures in the business world. Just a few brief topics to get out of the way before we begin. If you do have any questions during the presentation, you can feel free to enter them via the questions function in your side panel. I'll take all those questions and gather them together and pose them to our presenters at the end of the webinar. We also do have a soft copy of the slides available in the side panel under the attachment section, so you can feel free to download those and follow along with the presentation. The last item I'd like to cover is that we have a brief survey that will come up as you exit the webinar. It really only takes about 30 seconds to fill out, but it gives us a lot of great insight into how we can continue to make our webinars better for you. So with that, I'm going to pass it over to Michael and Paul and let them begin the presentation.
Thank you very much, and good morning and good afternoon to the participants of today's webinar. We are looking at the specific topic area of electronic signatures and electronic records. This is an extremely broad area that is rapidly developing. We are seeing this in every type of transaction, from financial transactions to general commercial transactions involving the exchange of records. Sorry, we had a little bit of a feedback issue. In commercial transactions involving the exchange of records. And we also, as part of our presentation, want to talk to you a little bit about issues concerning security pertaining to electronic signatures and records, and how sort of those issues fit within your overall information security and governance program. We are going to talk a little bit about EMV today, which is the Europay, MasterCard, and Visa program that all merchants are going to be subject to starting October 1. This is a very hot topic right now, and something that we are going to explore a little bit, but it would take an entire webinar in and of itself to explore all aspects of it. So with that, I'm going to turn it over to Paul to discuss some of the very specific starting points and legislative issues and frameworks that deal with electronic signatures.
Thank you, Michael. So what I want to do to start out is really just give a summary of the two key laws that kind of govern electronic signatures and electronic records in commerce. And this has really been a movement that's now about 15 years old in terms of legislating these electronic signatures and electronic records acts. Prior to that, there wasn't really a uniform statutory framework for how to deal with these. But in 2000, the federal government got involved and passed the Electronic Signatures in Global and National Commerce Act, which is appropriately coined eSign. That was enacted in June of 2000, and it established the validity of electronic signatures for interstate and international commerce. This was an important kind of turning point and has really kind of the watershed moment in opening the door for electronic transactions to become much more prevalent. What eSign does is it applies to federal and state law, and it basically codifies that an agreement is not invalid merely because it was entered into in electronic form or it was signed with an electronic signature. Before eSign, you'd see any number of challenges, court challenges to the validity of agreements on the basis that that there wasn't a wet ink signature, that it wasn't in traditional paper, hard copy format, and those types of questions. So eSign was really a watershed moment in 2000. In addition to e-sign, there's what's called the Uniform Electronic Transactions Act. That's called the UETA in a lot of respects. It was written and adopted by a commission that is responsible for drafting and advocating the passage of uniform laws within all of the 50 states. And as of today, 47 states have enacted the UETA, all states except for Washington, New York, and Illinois. And those states have each adopted their own similar statutes. The UETA applies to state law only, and so those transactions that fall outside the eSign Act because they don't deal with interstate commerce or international commerce are governed by the UETA. To the extent that a state like Washington or New York or Illinois has adopted something other than the UETA, it generally cannot be any narrower than the eSign Act. So these are the two laws that really have opened the door for electronic signatures and electronic records over the last 15 years. There's something that if you study the eSign Act or the UETA, or you're interested in this movement, you'll hear people refer to the three pillars of the eSign and UETA. It's basically the three main concepts that these laws aim at addressing. The first is that a record or signature may not be denied legal effect merely because it's in its electronic form. The second is that if a record is required, an electronic record is sufficient. And the third is that if a signature is required, an electronic signature is sufficient. So these three pillars really address the main objectives of the eSign Act and the UETA that we talked about with respect to the last slide. There are, of course, some statutory exceptions to the eSign and UETA. Most notably, the wills and testamentary documents, as well as some UCC transactions. The law has not come around to allowing those records to and agreements to take an electronic format in the same manner that it has with respect to other commercial transactions.
One of the things that we want to emphasize throughout the presentation is that the concept of an electric signature, as it's been talked about, is that it's really much more than our traditional thought process with respect to signatures generally. It can be a variety of different things. It's not just simply as you'll hear references in sort of the old case law to the marital signature, where in essence the process was that someone was competent to sign a particular piece of document to attest to the fact that they were the person who were actually presently attesting to the fact that they were engaging in that particular type of transaction, and typically there was a witness who might place their X or whatever on a particular document. And you still see documents like that today that are sort of what I would call old school methods of authenticating and authorizing specific transactions. But with the advent of electronic signatures, what we find is that sounds, symbols, or processes attached to or associated with a contract or other record and executed or adopted by a person with the intent to sign the record, that's sufficient. And so we have to sort of think about what does that really mean in terms of the whole gambit of possible electronic signatures. Well, it means that we could use PIN codes, for example. It means that we could use passwords to access a particular document. As many of you have probably seen, you have situations in which documents in standard commercial transactions require that people, sign their initials to a box. Well, you don't get that in the electronic document that's sent to you via computer. You get mouse clicks. And so you have to find ways in which these new types of signatures, new ways of authorization can be maintained in a way as a record, and under the UETA and the e-sign. These records have to be available. They have to be maintained in a method in which if there is some question mark about the authorization or authenticity of a particular document, that people have access to that. And we'll talk a little bit about authenticity and authorization later in the program, but we have to think about these things very broadly now and think about that, electronic clicks really are the methods by which some things are in fact authorized and commercially valid, such that the other side cannot simply repudiate a record. Now, with respect to the components of e-sign, Paul's going to talk about the issue of consent, but there are a variety of legal hurdles which we're going to address in this, and I'm going to turn it over to him.
So as Mike was saying, now the notion of a signature is much broader than it ever was before as we start dealing with these electronic transactions. But the e-sign and the UETA are very clear that notwithstanding the breadth of what can be considered a signature, there are some fundamental components that the signature must include in order to be considered valid under the law. The first and most important and probably the most obvious even to non-lawyers is consent. Consent is required to use electronic records and electronic signatures in lieu of traditional documents. So parties to a commercial transaction have to be aware of the fact that they're engaging in a transaction that is going to be consummated in an electronic form or involve electronic components, including an electronic signature, and consent to that format of transaction. Consent can, however, be implied, which is important. It means that merchants or retailers or anyone engaging in a transaction that they intend to use electronic records or electronic signatures for, you don't need an express statement or express written consent from the person you're dealing with. It just needs to be implied. And this is extremely important as internet and web transactions have become more prevalent and less, and the digital age has allowed for more and more transactions to take place digitally instead of in a face-to-face format. The next is that consumer transactions require an even more formal degree of disclosure and consent, though, than a business-to-business commercial transaction. So again, your consumer transaction might be, the purchase of a household good, such as a washing machine or a dishwasher, or a computer, or piece of software. Consumer transactions require formal consent instead of merely implied consent, and there have to be disclosures to the consumer prior to consent. So the consumer has to be informed that he or she has a right to receive paper documents. They have to be notified of the scope of the consent that they are giving, and this is important as more and more people enter into software as service transactions or any type of other kind of consumer service type transaction, where you might purchase a computer, for example, and expect software updates, or you might purchase a phone and expect software updates over time. The consent needs to make it clear to the consumer whether or not they are accepting and consenting to the use of electronic records and signatures for only a specific single transaction, again, for example, the purchase of the phone, or for many follow-up transactions, like all of the software updates that might come follow the purchase of the equipment. The consent needs to notify the consumer how he or she can withdraw consent if they no longer want to receive electronic records or use electronic signatures, and it must notify the consumer if there are any conditions regarding the access to paper documents and what those conditions are.
One of the things that we want you to keep in mind as we're going through this particular presentation is, the advent of electronic records is really a fantastic thing for commerce because it is designed for ease of use in terms of multiple approvals. It's designed to expedite transactions in a way that before required very traditional sort of, documents being generated then sent to a particular user, and in international transactions you'd have to wait for the mail to get something back, and sometimes you wouldn't even know if in fact the person who is purported to be the signer is in fact the person who was the contracting party. So that was something that was a gap, and there's a whole slew of cases about methods of authentication and authorization that formed around those types of transactions, and electronic signatures and record keeping are really truly designed to sort of eliminate a lot of the issues with respect to that. The eSign Act and the UETA do have components which talk about record keeping, and when we talked about early on the fact that this is part of your information governance issues that everyone has to deal with today, it truly is, because the Act, whether it's the eSign or UETA, says in fact that electronic records are sufficient to comply with record-keeping requirements. But that what is most important about that is that the records must be accessible to those who are entitled to it. And what they mean by that is not only do they have to have the parties to the transaction have to have access to it, but it has to be in a means and format that allows there to be an understanding of what exactly was transacted. How do we verify that in fact certain aspects of the record were in fact assented to? And so those are things that you have to consider when you deal with your various different technologies in terms of how are we going to demonstrate that in fact not only is this record the record of the transaction, but also that it's a record that is readable and understandable to the parties so that the transaction can be consummated and or implemented. The UETA, as we said, allows for transactions to be performed without human interaction, but merely by electronic transactions. I mean, we need to think about what that means. Again, if anyone has done a house refinance lately, typically you'll be sent to your email a document with eSign. It may be through VeriSign software or some other type of software, and it's simply a bunch of clicks on the keyboard, including a typed signature that that you would type in to express your consent to the transaction and the fact that you're authorizing that. So you have to then start thinking about, well, let's say that a part of the transaction doesn't go forward, and we need to validate portions of that document. So how are we going to do that? And there are sort of recognized technological issues that and other things that are now being implemented so that it will help in determining that issue of authentication. So as any of us, as trial lawyers, Paul and I are trial lawyers generally. We also do advice. We also do advise businesses from sort of the 10,000-foot level, and we deal with information security governance. We all know that electronic signatures and electronic records are not self-authenticating. What does that mean? It means that the signatures or the mark, whatever is indicating consent to a particular provision of the record, in and of itself, that check doesn't demonstrate that, for example, if I send something to Paul and Paul puts the check mark on it, I never see it. I never see that Paul is checking the box. I don't really know if he's behind the keyboard. And when he sends it back to me, and if our relationship goes bad and I need to sue Paul, I need to figure out a way to demonstrate that that contract is valid. So there are ways to do that. A party seeking to enforce an electronic record or a document signed by an electronic signature must prove that the other party actually executed the agreement. That's part of authentication. How do we authenticate? Well, in traditional forms where there were actual signatures, we did it a variety of ways. We had witnesses that would say, I recognize Paul's signature, and I know that Paul signs with a particular type of P when he signs his first name, and I can bring in 5 different people from his family who will all say, yes, that's Paul's signature, or someone who said, I witnessed Paul sign that particular document. Now, technology sort of, if you will, complicates it in terms of the explanation that's going to be given, but in some sense, it also streamlines because it makes it more specific to demonstrate that that particular document or provision of a transaction, and we can be talking about a financial transaction as well, that in fact was something that was authorized by the individual, by Paul in this case, as the person who in fact signed the document.
So this is where digital signatures come into play, and many people think that a digital signature is just synonymous with an electronic signature, but there really is a distinction. And if you think of the eSign Act and the UETA that Mike and I both spoke about at the beginning of the presentation as being the really big tent under which kind of all of the advent of all this technology and this field of law has kind of evolved, then as you start getting down to digital signatures, we're moving down into narrower subsets of it. The digital signature is really a subset of electronic signatures, and there's not a universal definition of a digital signature, but it's been defined by many different entities and trade associations. It's been defined in different pieces of legislation in different ways. But the general common denominator among all of the definitions of a digital signature is that there is some method built into a particular electronic signature that allows for someone to authenticate the transaction and authenticate the signature. So if you take a look at the slide that we have on the webinar here, we've pulled up 2 examples of definitions of digital signatures that we found in statutes, and those give you some indication as to what a digital signature is. You'll see that in the Guide to Medical Privacy and HIPAA concerns that addresses what a digital signature is for healthcare transactions, you'll see that the definition expressly describes it as including a cryptographic method of originator authentication. And again, this is very much like when the transaction that, very similar to the transaction that Mike was using as an example with the refinance, and you get the email with VeriSign or some other service. Those services, those pieces of software are basically have developed proprietary digital signatures. They have a methodology for including a cryptographic method of authenticating that signature. You can see that the California Government Code uses a little bit more of a simple definition of it, but it also, again, expressly provides that there is an electronic identifier in the signature. The characteristics of a digital signature are essentially that exactly that there's an electronic identifier, that there's some cryptographic means of doing the authentication that we were just talking about. Generally, the digital signature is represented in a computer as a string of bits of some sort of unique identifier that's a bunch of that, maybe binary codes. It's just a bunch of ones and zeros, or for those that are more tech savvy, some other kind of program code that's in the background that's stored and is unique for that particular signature and that particular transaction. A digital signature can be generated and stored on stored and transmitted data. So it doesn't need to be something that exists only on a hard drive. It can be something that it exists on transmitted data.
So as Paul said, part of the signature definition that has been used in the HIPAA area is, incorporates the term cryptography, and I don't want to go too much into what the science is and use too much in the way of cyberspeak, but you're going to get a little dose of that at this point, because it's sort of important to understand what the providers of sort of the vehicle through which the digital signatures have to occur in order to sort of consummate the transaction. Cryptography generally is a method of obscuring information, and you'll hear a lot about, if you read about digital signatures, that cryptography is utilized in some way in order to obscure information from point A to point B. And so what does that mean sort of in the modern lingo? Because cryptography goes all the way back to actually Egyptian times in some respects, because it is just a general definition. But what you hear now more frequently is, well, how do we encrypt the data? What do we do in order to transmit the signature or the payment information, which is something that'll be talked about later in EMV? How do we create sort of that virtual tunnel through which I know that when I transmit the information that I want Paul to sign, that there's a tunnel, and that only Paul is going to be the one who's going to be able to, in fact, consent to the transaction, verify that he wants to be a participant to the transaction, and in fact affixes his electronic signature. Well, what they have used in this particular area is something called the private key, public key type of encryption of data. Essentially, think of public key as, it's a ticket to get into, I suppose, the movie theater. And we all sort of know that you got to buy this ticket. My computer knows that I have the ticket. It also happens to know that Paul's computer has the ticket, but it's only the printing on the ticket, and in some form, whether it's through hash value algorithms, which really starts to get into cyberspeak, or SHA algorithms, but it's those keys that at a more granular level that says, okay, we have the tunnel, and I'm going to transmit data to Paul, and Paul is going to have a very, very specific key, and he's going to log in, and he may have to follow a link, and he's going to get that private key, And once he gets the private key, then he can unlock the information, and it's going to show up in the form of a document. The document is then available to him. This key is unique to his computer, and his computer can then go through and therefore verifying that it's him who is actually engaged in the transaction through a variety of passwords. And he can go through the document and then, in fact, validate what it is that I need him to validate, or transmit the payment information as I need him to transmit it. That information is then sent back to me, and the way that I get access to his information is that because he's initiated the process, I also know the private key, and I can now use that to unlock the information and have a verified, consummated, authenticated transaction. Now, how does that show up? It shows up in the form of things called hash values. Hash values, essentially, without boring you with the computer science, is a way, it's in essence an algorithmic fingerprint. It's a way to establish that a particular transaction is identified by a unique set of numbers. And that's the method through which digital keys and now digital signatures are verified and therefore authenticated. The digital signature standard has been approved by the Department of Commerce. It has been changing. There have been suggestions that perhaps biometrics should also be included as a further means of authentication. Biometrics essentially are, fingerprint data, retinal scans, things like that. That's sort of the next generation. But I'm going to digress for one moment here to just say that it is interesting that in the paper this morning that OPM is trying to figure out why it is that the Chinese, when they hacked into the OPM database, that they took 11 million federal employees' fingerprint cards. And a lot of experts are opining that the use of that biometric data can be utilized in some form of sort of validating transactions in fraudulent types of schemes. And so it just demonstrates that all this information must be under extreme lock and key when, in fact, we go the route of utilizing it. EMV, which I'm sure for a lot of you is something that is near and dear to your hearts, because you have to deal with changing out your payment card processing systems to move over to this. EMV is not really a very fancy acronym. It just really stands for Europay, MasterCard, and Visa. It is an international standard that defines the interoperability of secure transactions and payments. We know it to be essentially the point-of-sale terminal transaction where credit card information and or ATM type banking information is transmitted from the vendor to the bank and ultimately the vendor's account to get payment. The change really was that the old method, which is the one that was used in the United States for a long, long time, was the old strip in the back of the card. And that was sort of a static method of authentication. The document, the card itself, always registered the same code. There was no variation, and that code was read, and there was by the machine, and then it was transmitted for payment. It was an easy target for fraud. The Europeans actually embraced EMV very early in order to create this more sort of random sequencing of information that is sort of unique to each transaction. And it creates a digital signature just like we talked about before, but it's one that is much more difficult to replicate. There is encryption to protect the PIN and not the transaction data. And of course, there's an overlay with PCI and your payment card industry standards that there is supposed to be end-to-end encryption from terminal to terminal and ultimately to the bank in terms of processing the digital signature, if you will, all the way through the transaction. And again, its purpose is to reduce fraud.
So PCI is that Mike just mentioned is another digital signature standard, and it's unique to the payment card industry. It's currently in its third version. It's version 3.1, which is published in April 2015, and it is developing and evolving extremely rapidly. I believe the first PCI digital signature standard was published in 2010, and it seems to be evolving on an annual basis, if not more rapidly than that. What the data security standard does with respect to the payment card transactions is it's meant to complement EMV, because as Mike mentioned, although you have with EMV a much more dynamic and much more secure digital signature and transaction, there is still data that's being collected, and that data needs to be protected. Again, this really is just an emphasis on the fact that as digital transactions and electronic transactions become more and more prevalent, it's providing a lot in terms of convenience and commercial opportunity, but it's also leaving behind all of these pieces of data that need to be secured. So the PSI DSS has been adopted to protect data that's collected in EMV transactions as well as non-EMV transactions. So think, for example, when you go to the store and you're at the payment terminal and you have to put in your PIN to use your card. Whether it's an EMV card or it's not an EMV card, that's data that has then been transmitted by you to the terminal and has potentially been stored. So that needs to be protected. And the PCI DSS outlines the technical and operational requirements that need to be implemented in order to protect that data in the payment ecosystem. And again, it complements EMV. EMV is really meant to create a more secure transaction, and the PCI DSS is intended to secure the information that is used in connection with that more secure transaction, or even more so with the transactions that are less secure than EMV. As Mike mentioned, the USA is late to adopt EMV. EMV has been used much more prevalently in Europe. According to one study, as of 2012, which these numbers are obviously a little dated, but they illustrate how slow the United States has been to adopt EMV. As of 2012, there were only 1.5 million EMV cards issued in the United States as compared to more than 800 million in Europe during that same period of time. The payment networks have initiated a liability shift that will begin affecting merchants and retailers beginning October 1 of this year. This is likely why that Mike mentioned that this is near and dear to your heart. The liability shift is basically meant to put some pressure by the card issuers on the merchants and retailers to begin accepting more responsibility for the security of transactions and the authenticity of transactions. And so retailers that have not installed and begun to implement the use of EMV terminals as of October 1 will then begin bearing the risk of liability for fraudulent transactions that traditionally was borne only by the card issuer. EMV is really an opportunity to address, the future of e-commerce. It's, while it has been adopted for a long time and used very prevalently in Europe, as we talked about, it is new to the United States, and it's really a sign that we're beginning to look to more sophisticated technologies in order to address our security concerns in payment transactions and commercial transactions more broadly. EMV's dynamic chips don't specifically address security concerns related to, say, for example, online transactions. So, as lawyers and as retailers or other commercial entities, we really need to begin to focus on what might come next, what other technologies might be adopted in order to enhance the security of commercial transactions and electronic transactions, including online transactions. Mike mentioned biometrics. There's a possibility that there would be more dynamic passcodes and other forms of chip authentication, and there's all sorts of other technology that may be coming down the pipe here. So it's important that we, as those of us that are interested in the field, that we stay abreast not only on the evolving technologies, but also how that might impact the legality of any particular commercial transaction we engage in, or our obligations to protect the data that we encounter and avoid, enhanced liability at the expense of enhanced convenience.
As we talked about the biometrics issue, I just want to say I think what we're going to continue to see is we're going to continue to see the electronic signature or electronic assent to transactions continue to dominate, and you're going to see less and less actual paper signings. I think what you're also going to see is you're going to see the use of the electronic assent as a method of, while it's a method of implementing a transaction and its terms, you're going to see the security areas around it also become more robust as these transactions take on more of a sort of a daily and central focus in your businesses from day to day. Biometrics is certainly one area where there's been a lot of discussion. You don't have to look far past your iPhone to see that, even iPhones have adopted biometrics in rudimentary form to validate that you are in fact the user of the phone through your fingerprint. Retinal scans are starting to become increasingly used in certain types of transactions and interactions where verification of an individual and the individual's participation in some form of exchange with, say, the government or something like that becomes increasingly important. So security, hopefully you'll come away with the fact that this is something that is extremely important from the standpoint of, while the signature itself allows for greater ease of use and that it certainly facilitates transactions and global commerce, there is sort of another component to that which is inextricably intertwined, and that is the security component, because we're always trying to figure out how to keep this information secure in some form or fashion, and that is sometimes a 24/7 job. I will tell you that, a little bit about some of the risk issues. Retailers, it's not going to be a surprise to you that you have to be PCI and DSS compliant if you accept, transmit, or store credit card information data. That's something that's mandated both by some of the PCI standards, some of the terms of service by the various different credit card holders. It's even mandated by various different federal and state laws, which affect some of these particular areas. Sort of the bad scenario, nightmare, if you will, from a business perspective, is if you don't maintain those types of standards and aren't vigorous about this, that the class action lawyers view this as their next growth area, and they're looking for opportunities for class-wide liability for data breaches involving retailers, failure to implement EMV. Could be a basis to in fact provide a cause of action for them, because EMV is considered, for better or worse, the new standard with respect to transactions. So we need to be thinking about all these things. It's not just one singular area. It's really part of an overall theme of information governance. And I think at this point we've come to the end of our webinar, and we're happy to take questions. Also, at the very beginning of our presentation, we have our email addresses, so if there's anyone who wants to reach out to us and has a specific question, we'll try to address it.
All right, great. We do have a couple of questions that have already come in online. If anyone does have any questions additionally, you can feel free to pose them via the questions function now. So the first question that we have is, are electronic signatures valid anywhere internationally as well?
Under the e-Sign Act, yes. So to the extent that you would be enforcing that international transaction in the United States, yes. If you were to go to court in some other country to try to enforce the agreement, then you might be depending on the terms of the agreement and which law is supposed to apply. There may be some question as to whether or not that host country or forum state has adopted something similar. To the extent that you were in any of the Euro nations or any of the major economic partners of the United States, there wouldn't be a question, too much concern about the validity of electronic signatures, electronic agreements. They're pretty much universally recognized and acknowledged. As you start to get to more emerging states and states that have less robust statutory schemes, then there might be more of a question. But this is, it's a very good question, and it's an important point for reminder for parties to think about where they're going to litigate disputes arising from their agreements before they consummate that agreement, so that it's very clear in the terms, and that it's clear what terms apply. So to the extent that you're engaging in, that you're entering into commercial transactions and contracts with companies abroad, then it's important to think about whether or not you want those to be handled in U.S. courts, and whether or not there's jurisdiction over the party you're dealing with, or whether or not you want it to be handled in arbitration here in a particular state, or in front of an international arbitration tribunal. And those are all concerns that everyone should be thinking of when they enter into their commercial transactions, whether electronically or otherwise.
All right, great. The next question we have here is, are banking institutions accepting electronic signatures when references are being requested?
Increasingly, yes, they are. And you will see that many of the large financial institutions are in fact utilizing various methods of e-sign in order to validate or accomplish these types of transactions.
All right, great. We have a couple questions here on commercial credit applications too. So the first one is, are e-signatures valid on them, on commercial credit applications?
As a general matter, yes. Again, in a credit situation, like Mike was mentioning, the creditor, the banking institution, has a great deal of leeway to kind of define the parameters within which they want to deal with their consumers or their applicants. But under e-sign and UETA, those are generally that's generally a category of transactions for which an electronic agreement would be, or an electronic signature would be permitted.
Oh, and a lot of it goes back to what Paul said earlier, which is a lot of it also depends upon what the parties are contracting. And so the terms of the contract will ultimately govern whether or not it's acceptable. But as a matter of law, yes. I mean, these are really the types of transactions right now that are the most heavily reliant upon e-signatures.
All right, great. The next question we have here is, can electronic signatures be notarized?
That's a really interesting question. From a pragmatic standpoint, I'm going to go out on a limb here and say no, just because I have not seen any technology that's offered that service. So software providers and entrepreneurial people out there, maybe there's the next frontier. But generally the objectives of having a notary having an agreement notarized, and the requirements of the notary are going to require there to have actually been an in-person witness to the execution of the agreement and a physical signature by the notary about that actually took place.
And I'm going to follow up and say, I suppose there could be a scenario where if you wanted to be doubly sure, where you could e-sign a document and then subsequently, like for example in an escrow situation, then take it before a notary and require both the e-signature and the notarization. The e-signature, because of the MD5 hash that's supposed to sort of recognize and uniquely identify the transaction, that's supposed to be in some ways a substitute for the more significant issues attached to a notary. But I could see a scenario where a party would say we want to have both an e-signature and then subsequently have a document that's notarized separate and distinct from the e-sign document. There's nothing that precludes that from happening.
Right. Yeah, Mike's right. I just think that the important takeaway is at this point there's no way to electronically notarize a document. You still need an actual witness who's a licensed notary and is given and has the authority to administer oaths and do all of those things.
All right. The next question we have is, would an electronic signature hold up for a personal guarantee?
Depending on the subject matter of the contract, yes.
Okay.
It is as good as any signature, so yes.
All right. The next question we have here is, could you share some of the pros and cons of the different methods of electronic signature, specifically using a simple acceptance of terms versus a more image-based publishing of a signature like Adobe?
Is the question referring to a specific format of a digital signature or just electronic signature more generally?
I believe it's talking about a digital signature.
Well, the use of a digital signature, period, is preferable to just an electronic signature because it provides the basis for authentication, as Mike spoke about in the presentation. To the extent that there's less interaction between the parties to the commercial transaction, that becomes increasingly important because the basis for authentication becomes, or the need for authentication is likely to become a bigger issue. If you're dealing with a business-to-business transaction negotiated between in-house counsel at a company, or the COO and of one company and the COO of another company, and there's an extensive record of emails between them and face-to-face meetings, then a simple electronic signature is more likely to be sufficient. There's just going to be plenty of records that will mitigate against any risk that someone is going to disavow that they signed the agreement.
And in theory, there really should be the way that the transaction is supposed to be sort of uniquely identified is essentially the same whether you use Adobe or whether you use some other method, because ultimately it's going to be done, the authentication will be done by an MD5 hash, which is probably too much computer speak, algorithm. And that algorithm is going to identify the transaction through a unique signature algorithm, which is essentially as good as a digital fingerprint. When people talk about trying to verify something electronically as being unaltered versus the original document, well, the way that that's done is by taking sort of what's called the hash value of the original and compare it to the hash value of the altered, and that will tell you whether or not it's an identical document in and of itself, and so, or not. And so essentially the technology, whether it changes a little bit and you use the Adobe version or not, ultimately is going to depend upon certain mathematical algorithms to verify the transaction.
Okay. The next question is, if there is a commercial credit application, should they address that they would accept e-signatures as valid?
Yeah, they can certainly do that in the terms of, you mean in the terms of the agreement?
Yes.
Yes.
Okay.
Yeah. As a general matter, any opportunity to define your terms should be seized upon.
Yes.
Okay. The next question that we have is, what is the current case law in situation where someone claims fraud and can prove the signature was not their own? And how prevalent are these cases becoming with e-signs becoming more accepted?
There is very little case law in this area. We looked for case law in this area and found, what, nothing? I didn't even find a single published opinion in this particular context. It's interesting because we expect the prevalence of fraud with respect to these types of transactions to have increased, but at least right now, in the aftermath of the e-Sign Act, we have not seen a lot of litigation over these particular issues.
It really does, though, highlight, again, just to go back to another issue Mike was talking about during the presentation, is kind of the important interplay here between data security and then these transactions. I wouldn't be surprised if, as more and more data is exchanged and stored, that people get fraudsters get more sophisticated in their ability to apply that data to digital signatures and to electronic transactions, and we see more of that stuff.
All right, great. Then it looks like the last question that we have here is sort of a hypothetical situation. And the question is, if an e-signed document is sent to a client via email and they claim that someone else signed it instead of him, how can they maintain the legality of the signed document and his consent, if there is a way?
Well, this again goes to whether the first question you'd have to address is whether or not you're using a digital signature, and then as Mike was talking about, what's the architecture of that digital signature program. If you go to the real common example that Mike relied on during the presentation of the refinancing situation, you might get an email from your mortgage broker with the documents that need the disclosures that need to be e-signed, but that's not a simple electronic signature. That's a digital signature. It generally involves a DSS compliant, proprietary digital signature program and some sort of authenticating information in order to activate it. So that's why you'll often have to put in a mother's maiden name, the final 4 digits of a social security number or something like that. So to go back to the hypothetical, I would say that if you think that there's a risk of that happening, then it will make your investment in some sort of digital signature program or methodology all the more worthwhile.
And to the extent that it has happened, then you're going to need to probably talk to your e-signature vendor to ensure that those sort of backup systems in terms of the MD5 hash values and those sorts of things which verify that the transaction was in fact consummated, that those are available to you and can be used if in fact this is someone who is now repudiating that he engaged in the transaction.
And worst case scenario, to the extent that it's ever litigated, then it'll just become an evidentiary issue for the trier of fact. And as trial lawyers, Mike and I deal with cases all the time where there's disputed issues of fact, and we go in and we look, we would look at the metadata of, on the computers of the parties that were the parties to the lawsuit. You could subpoena information from the email providers. You'd take depositions, and you'd just suss out whatever evidence you need to prove your point.
None of which anyone wants to have to go through, but sometimes it does come to that. So.
All right, great. Looks like that's all the questions that I have on my end, so we're going to wrap up the webinar at this time. I'd like to thank Mike and Paul for taking the time to present to our audience today. And I'd also like to remind everyone that if you could fill out the brief survey we have on your way out of the presentation, it gives us a lot of great insight into how we can continue to make our webinars better for you. So with that, I'd like to thank Mike, Paul, and Aaron Fox, and hope everyone has a great rest of their day.
Thank you.
Thank you.